In essence, it is a new type of sentence which the courts can impose. It will apply to offenders who are 21 and above at the time of the commission of the offense. It will cover dangerous offenders who commit serious, violent, or sexual offenses, and provided there is an assessed risk that they may commit similar offenses after they are released. The relevant offenses will be set out in a new schedule to the CPC. They will include culpable homicide, attempted murder, rape, and sexual penetration of minors. The SCPP is different from normal prison sentences under existing law. The court will specify a term of imprisonment for the offender based on the facts of the case. But the difference is that this is a minimum term. There will be no early release or remission. The court will also say whether the offender is released at the end of the minimum term will be subject to a review. If he is assessed to pose a risk to others when his term ends, he can be kept in custody beyond the minimum period. And if he is released, conditions can be imposed until it is assessed that he is safe to be released. First, we hope that this will enhance public protection. An offender who continues to pose a real danger to the others should not be released. Second, the SCPP will actually, hopefully, promote rehabilitation. An offender sentenced to the SCPP will have a very strong incentive to take his rehabilitation seriously in the first period of sentencing. Otherwise, he jeopardizes his chances of being released. Third, as I mentioned earlier, the SCPP allows for a more calibrated approach to sentencing. With the SCPP, the sentencing judges will now have more assurance, greater clarity, because the sentences they impose are only the minimum. There will be a further risk assessment with experts at the end of the minimum term. This can actually result in the court imposing shorter sentences up front. FMEs broadly consist of physical medical examinations, collection of body samples, and taking photographs of body parts. These processes are now become very important for getting evidence in offenses like rape and sexual assault. First, we take a differentiated approach towards accused persons and victims. So accused persons, one approach, victims, a different approach. For accused persons, police can require them to undergo FMEs even if they do not consent. Reasonable force can be used if the FME doesn't relate to intimate body parts or invasive procedures. But it will be an offense for an accused person to refuse an FME unless he has a reasonable excuse. For example, if he has hemophilia and giving a blood sample could endanger his life. The court can also draw adverse inferences from an accused person's refusal to undergo FMEs. In the case of victims, consent is generally required for FMEs. However, there can be exceptions. For example, FMEs may still be conducted if delays will result in the loss of evidence and the victim is not able to give consent within a reasonable time due to a physical or mental condition. This could happen, for example, where a victim is sexually assaulted, falls into a coma, and has no prior authorized decision maker to give consent. In many cases, time can be critical, especially for DNA evidence, because DNA can degrade very quickly if it is exposed to the environment. Allowing FMEs to be taken in these cases is in the interests of both the victim and the public. It can make the difference between catching the culprit and him going free and worse, committing more such offenses. There will be safeguards in place for both accused persons and victims to ensure that FMEs are conducted safely and sensitively. For example, Only qualified medical professionals can conduct physical medical examinations and invasive medical procedures. Before taking a body sample, the person conducting the FME must be satisfied that it will not endanger the subject. Only police officers holding the rank of inspector and above can require a FME involving intimate body parts. If the person undergoing an FME involving intimate body parts is a lady, the forensic specialist or police officer carrying out the FME must also be a lady.
Mr. Derek Goh asked if the victim can request to remove FME information that was collected without their consent. To reiterate, FME information will only be collected without a victim's consent in exceptional circumstances. If forensic evidence has already been collected under such exceptional circumstances, the evidence will be retained to allow the police to solve the crime and bring the perpetrator to justice. The information of the victim will be kept confidential and used for investigating the case at hand. Ms. Usha Chandradas and Mr. Raj Joshua Thomas had questions about the use of reasonable force on accused persons. Police will first look at the facts and circumstances of the case before deciding whether an accused person should undergo FME. There is time sensitivity in obtaining forensic evidence to minimize the risk of contamination. This is especially so for DNA evidence, which degrades rapidly when exposed to the external environment. It would therefore not be feasible to require a warrant from the courts before proceeding with the FME, including using reasonable force to carry out the FME when required. Police have established protocols on the use of force. What constitutes reasonable force will depend on the circumstances of the case. Examples include pulling on a cheek to swab the inside of the suspect's mouth and holding the subject's head still to obtain a hair sample. Ms. Sylvia Lim asked about the training of auxiliary police officers or APOs in the conduct of FMEs. Reasonable force cannot be used on a victim and on FMEs involving intimate parts or invasive procedures. APOs undergo the appropriate training, which includes the use of reasonable force.